Morning, everybody. This is hearings on council designations of the Kātata District Council, the Marsden District Council and the South Wairarapa District Council in relation to designations that are proposed to be rolled over with or without modification and some new designations. My name's David McMahon. I'm an independent resource management commissioner based in Wellington. And as you can see, I'm sitting alone today without the assistance of any panel members, so feeling quite vulnerable up the front here. I've just explained offline to the participants how we're going to run this hearing, and it's going to be a hybrid approach where we hear from the Section 42A officer initially, and that's Morgan Fallowfield. She'll give an overview of the designations, but won't get into any specific details on those designations that are contested. We'll then hear from the requiring authorities for those designations from South Wairarapa District Council, which is Mr. Peter Trafford, is it?
David, yeah.
Have I got your surname right, Trev?
You do, yeah.
You're the asset manager at South Wairarapa?
Well, they call me the principal engineer through Waters, but whatever works in this context.
Thank you. And I think we have online Philip Evans, who's the asset manager at Marsden District Council. Can you hear us okay, Philip?
Yes, I can, sir. Thank you.
Thank you. And thank you both for attending. Okay, and then we will move to the submitters, to the two designations that are contested, being Payne Farm, represented by Eastleigh, Mr. Davies and Ms. Foster, and the submissions on the, that's Riversdale, sorry, Riversdale, and the submissions on Payne Farm. There are two submitters that are sought to speak, and they're not present at the moment, but thank you, Ruth. They're on their way, apparently. Once those submitters have been heard and questions have been disposed of, we'll go back to the reporting officer's recommendations, and then both Philip and Peter, you'll have a chance to summarise the case and respond to any matters raised by the submitters, and then I'll adjourn the hearing. Okay, well, we're in your hands then, Morgan. Give a summary statement.
I do have a summary statement here, and if I could take it from paragraph 5, if that's okay.
That's fine.
So there are 92 designations and requirements in the proposed plan from the district councils that were received from Kātata District Council, Marsden District Council, and South Wairarapa District Council. 15 of these are rollovers of existing designations from the operative plan into the proposed plan without modification. 62 are rollovers of existing designations with modification, and 15 are requirements for new designations over existing facilities. There were 14 submissions, 15 submission points relating to council designations or requirements. None of the 14 submissions received were from the district councils as requiring authorities submitting on their own designations or requirements. One submission point sought retention of designations or requirements as notified. One submission point also sought retention of designations or requirements, albeit with requested amendments seeking minor technical corrections such as designation purpose, legal descriptions, address and mapping of designation boundaries. 11 submission points and 2 further submission points were received seeking the notice of requirement for the Martinborough wastewater land-based disposal Payne's Farm be rejected. Would you like me to carry on?
Before you do, can I just get a some clarification on the numbers of, clarification on the number of submissions.
Yes.
There were 14 submissions in total.
Yes.
Of which 11 were from Payne Farm, is that correct?
Yes. Majority of the submissions were on Payne's Farm.
Yes. The other 4 submissions, what were they in relation to?
From memory, there was one on the Martinborough manganese plant.
Yes.
And one from Eastleigh on the Rivers
Yeah.
Dale.
Yes.
There were others that perhaps haven't been captured that were further submission points
Okay.
that were also in relation to the Paynes Farm
Yes.
water treatment.
Yes. Okay. Thank you. I'm happy for you to carry on with section 4, and that sets the context for the requiring authorities to speak.
Okay, thank you. So responses to pre-circulated expert evidence. I read the respective evidence of Christine Foster for Eastleigh Limited and the memorandum of Phil Evans for Marsden District Council. Ms. Foster's evidence notes that at the date of preparing her evidence, no evidence had been supplied by Marsden District Council as the requiring authority for the notice of requirement for the Riversdale wastewater treatment plant and disposal. As a result of this, when writing her evidence, Ms. Foster was in the same position as me in not being able to conclude that the requirements of section 171 of the RMA are met for the requested designation. In absence of any further evidence, Ms. Foster's view is that no case has been made to justify the requested designation of lot DP 451871. I acknowledge Ms. Foster's evidence. Mr. Evans' memorandum responds to Eastleigh's submission point relating to the notice of requirement and proposed designation relating to the Riversdale wastewater treatment plant. I also acknowledge Mr. Evans' memorandum, and I reserve my position until after the hearing from the requiring authority and submitter.
Thank you. And I think we'll leave that at that point. We'll now move, I don't have any further questions at this point. We'll move now to hear from, well, is there a gentleman, Philip or Peter, do you have a preference as to who goes first?
Seems like Payne Farm is pretty pithy, so maybe we'll go for that first. Unless Philip just wants to get his stuff done. And
So up to you. So I mean, it sounds like there's only one submission for Eastleigh. Perhaps it'd be easier to deal with that first and to get it out of the way, and we can then move on to Payne Farm, which may have more submissions to hear. I mean, in your hands, sir.
I think we might proceed with Payne Farm first, because we've got council and planner for Eastleigh present who want to present in relation to this Riversdale designation. So we'll proceed with yourself with Peter first.
okay. Thank you. First time presenter at one of these hearings. Apologies if I get any protocol wrong. I'm a process engineer by training, wastewater and water design engineer in the last few years, and recently engaged by South Wairarapa District Council as the Principal Engineer 3 Waters, responsible for the ongoing operation and maintenance and upgrade of assets. South Wairarapa District Council has a resource consent for the treatment of Martinborough Township's wastewater at its existing facility, and then a partial and conditional discharge of that treated effluent to land where possible, in a staged fashion with some future upgrades as part of that resource consent application and hearing and granting. The other option is discharge of that treated effluent under other conditions, but not preferred, into the Ruamahanga River close by. Currently, the land disposal takes place in a smaller parcel of land adjoining the wastewater treatment plant under deficit irrigation. such that in the summer there's a lot more that can be disposed of to that land, and in the winter, in the soil moisture gets high, there's a greater amount that goes into the Ruamahanga River.
Yes.
That is deemed to be called Stage 2A. Stage 2B was to be the development of a larger area for land disposal of treated wastewater effluent from that same facility under those same conditions of concentration and residual pollution in that wastewater treatment plant effluent to an area known as Payne Farm, which is bound to mess this up. It is owned by a trust, Payne Farm Trust, which was set up to administer and create opportunities for the children of Featherston by taking income from Martinborough.
What to do with Featherston? You said Featherston.
Oh, well, sorry, it's a plug for my own town. Apologies, everybody. I've been adequately corrected. For the children of Martinborough. So using the proceeds of the income of those farming activities to provide income to the trust, which then distributes it to the children of Martinborough. And I think that there is some supervision of that by the Martinborough Community Board. The proposal of Payne Farm to be used for the disposal of wastewater effluent was part of the resource consent just previously discussed, which was granted, and plans are underway to begin or have that done no later than the required date of required year of 2030. And so that designation under the combined district plan is there for that purpose. So I guess switching to something a bit more comfortable with, which is engineering and the treatment of wastewater. Martinborough produces sewage. That sewage goes to a treatment plant. That treatment plant then partially cleans it. And I say partially because I also do water treatment for potable water, and I would never consider wastewater treatment of any nature to be completely clean. That partial cleaning is done to a required standard, and then by a process of biology, aeration, oxidation, stabilization, and some UV ultraviolet disinfection for inactivation of pathogens, such that the quality of the treated effluent is suitable to be reintegrated into the environment in whichever way meets the conditions of the resource consent and the process of assessing resource management appropriate to those areas. For a while now, and I say while loosely, but I think in 2012, South Wairarapa District Council produced a policy or a strategy of encouragement of disposal or treatment of the final effluent to land. And so that context provided the basis of that application. So Payne Farm, I guess, is the nominated and designated land for that activity come 2030. And so South Wairarapa District Council, I guess in summary, sees the need to keep that designation right there on that parcel of land. Not sure if there's any other matters that I can adequately cover other than that. Have I done? Have I set the scene?
Set the scene nicely and created some questions for me, if you don't mind. Was there anything further you wanted to add at this point?
I don't think so.
Okay. Look, I appreciate you're not a planner, Peter, but there are some planning issues that have arisen. So I need to put some questions to you that you may or may not be able to answer. So let's just start with an inventory. So the Martinborough wastewater treatment plant is currently made up of some ponds, or a large pond, and some land which serves as a partial disposal field for that, with any excess disposal going to the river. Is that a layperson summary of the situation?
That's a good one. I think the there is an important extra step, which is the UV disinfection, just because it heavily reduces the risk of
Yes.
Transmission of disease from treated wastewater to people and animals.
Yes. And that situation I've just described is roughly encompassed within stage 2A of the plan for the Martinborough wastewater situation.
Yes, that's correct.
And that relies on a combination of an existing designation in the operative district plan, S15, which is the Martinborough wastewater treatment plant, which has been sought to be rolled over with modification. I will need to see a copy of that rolled over designation. It's not part of the material that's in front of me. So if you're able to provide that to Ruth, that will get to me in due course, and I'll set a time frame for these in due course. But essentially, as we've just discussed, that provides for the treatment and disposal
Yes.
of wastewater. And that's quite separate from the Paynes Farm site, isn't it?
It's geographically separate,
Yes.
for sure, and a separate stage in time.
Okay. The designation, the situation with Paynes Farm is that the South Wairarapa District Council hold a resource consent from Greater Wellington for the disposal of contaminants to ground and to water
And, yeah.
and to air. That was granted in the around 2014, 15, I believe.
I actually don't know, I'm sorry.
Yes, I should know because I was one of the commissioners on that. I wasn't the chair. I was part of a 3-member panel, which I disclosed as part of the proceedings for this hearing. And I believe that has a 35-year lapse date, and I think that takes us through to 2050, which would suggest that it was probably 2015 that it was granted. That resource consent, has that resource consent ever been given effect to?
Yes, it has.
Out of an earlier stage?
So we are currently operating under that resource consent. The giving of effect to means to begin operating under that resource consent, and the stage 2A, for instance, resulted in the construction of a travelling irrigator to do what was applied for.
Yes, okay. Is there any disposal of effluent onto that site? Has any occurred to date?
Yes, that is regular daily occurrence for the last 4 or 5 years, I think.
Yes. If it hadn't been given effect to it, it's arguable that resource consent could have lapsed, but I just can't remember. Normally there's a 5-year lapse date, but sometimes applicants seek to extend that to 10 years at the time that the decision's issued. I'll need to refresh my memory on that. So that's the regional component of Paynes Farm. The district land use component is the subject of today's hearing, and that's a proposed new designation number S26, which is for the Martinborough wastewater land-based disposal Paynes Farm. Again, I have not seen a copy of that notice of requirement, so I would like to see that. And that puts me at a little bit of a disadvantage, Peter, because I'm trying to reconcile in my mind what the need for the designation is. You have regional authorisation for the disposal of effluent. The proposed land designation for this new designation I talked about is 26 won't and can't have any jurisdiction over the disposal of contaminants. It'll be more to do with land use components such as structures, those sort of things. And without the notice of requirement in front of me to actually understand that, I'm struggling to understand what the necessity of the designation is, and that's one of the tests under Section 171 of the Resource Management Act that I have to have regard to. I need to understand the necessity of the works and the necessity of the designation, the effects of the designation, whether alternatives are being considered, and I need to consider some policy ramifications which are more on the planning field. But I'm just struggling about the need for the designation as a technique.
Yes.
To authorise works over and above what's already authorised by the regional consent. Are you able to assist me in that respect?
Not very well, I'm afraid, but I've got my able companion. Russell, will you be answering these questions?
I may also able to help here, David. I do have a copy of the notice of requirement. I could provide you with that if that was to assist.
Do you have it electronically?
Yes, I do.
Okay, well, you said that through. I'll pick it up on my laptop. But in the meantime, Mr. O'Leary, how can you assist in this respect?
I would sum it up in simplistic terms to help for your awareness and build your knowledge. The designation is one of a tidy up process to capture the exact intended use on the subject land. That is what, and moving from the earlier reference of land for waste, it is to acknowledge the ongoing hard waste operation on site, but also recognise the intended purpose of treated wastewater to land-based disposal on that site, as well as the hard refuse waste. So making it clear as this designation should be in terms of the purpose sought by the TA. And Morgan can add further wording to that, should you need.
Yes. Still struggling a little bit, Mr. O'Leary, to understand what aspects of the South Wairarapa District Council's functions and jurisdiction as a district planning authority the designation would relate to. I mean, we know that the Regional Council have authorised the disposal of wastewater in terms of a disposal of contaminants to land and water. What aspects of the operation over and above that need consent under the proposed combined district plan that aren't already covered by the Regional Council authorisation?
Could be the infrastructure involved with irrigation, such as pipes and pumps, and
Would be the practice of the operation of the disposal activity.
so one thing that it may cover from an engineering perspective is that there will need to be pumps and irrigation infrastructure, drippers and disposal, sprinklers, and there will be some that will be above ground. Some of that will be above ground.
Yes.
So I guess I'm just offering the possibility that is what this designation covers.
And some will be below ground too.
Yes.
Yes.
Yeah.
Will they involve earthworks?
Yes.
Yes.
It's invariably going to involve earthworks. There, depending on the design, it's a long way from the wastewater treatment plant to farm, so there may be some continuous pumping and to a small storage lagoon or pond, and then rapid pumping when needed to the irrigation, just to cut down on friction losses and energy costs.
Yes.
So potentially that may have been what's intended to be.
We bring the something on the. Can we bring up the copy of the Payne Farm on the screen, please?
I've just sent a copy of the notice of requirement to Ruth there. Would you like a copy of that shown on the screen?
Yes, that would be useful. Need to log in there.
Logging into the call before I can share my screen.
Mr. Evans, you might want to turn your camera off, and we'll call you up when you need it. Thank you.
So this is the notice of requirement letter. It deals with all of the notice of
Yes.
requirements
Yes.
for the council. So I'll just scroll down to the relevant part for Paynes Farm.
That would have been the rollovers as well. Yes, as well as the new designations. That would have included the Martinborough manganese reduction plant also.
Yes, it does.
Yes.
Yeah, which is shown there.
Yes.
This is the first paragraph or section that relates to the Martinborough wastewater land-based disposal.
Yes. Just hold there a minute. Okay, that fourth paragraph is new information for me, that an area of Payne Farm is already designated in the operative district plan for waste disposal purposes. The new designation will overlay across this existing designation. So we're aware, Peter, that there was a partial designation already over Payne's Farm.
I guess, to be blunt, I don't generally consider designations in my daily life very much. So as I understand it, that's the transfer station for solid waste.
Okay.
Waste, rubbish bags and drop-off points and things.
Okay. Martinborough transfer station is designation SO2. And this is SO52 by the sounds of things. So
Page 33.
of
Designations is the main.
okay,
Would you like to see that now?
yes, please.
There's a caption here that reads existing designation is shown in yellow, which is the waste transfer station, and the proposed designations in red.
Is it align with your understanding, Peter, on what you just said?
That's the correct location, and yes, and the transfer station shown in yellow, correct?
Yes. So just to orientate me, where's the treatment plant in relation?
Up off the page, but up the top.
Yes.
Past the top of the photograph.
Yes.
Some distance away, actually.
Yes.
2 kilometres probably from the top of the page.
Can you just give me the context to this by scrolling down so I can see what came before the plan?
Sure. So this is the end of the document, which has each of the designations in the appendix there. So before that, there's an assessment of effects, and that's
okay. So they're grouped under
the groups based by, for example, wastewater treatment.
yes,
and the relevant ones within the district there.
Okay. Hey, can you just scroll down further, please? Sorry. Yep. Boop. Just go back to the 4.3, the heading 4.3. And 4.2, sorry. Keep going up. Okay. And keep scrolling down now. Sorry, it's 4.2 onwards. 4.4. Stop. And carry on. Carry on. And 5. Okay. 5.1. Stop. Yes, and carry on. Wait. Okay, thank you for that. Thanks for everyone's patience on that. It's a fairly generic description, Peter. I didn't see any volunteer conditions in relation to the designation in terms of hours of operation or control of structure, height, or location. Nothing in terms of visual screening, etc. That's proposed. Are you aware of anything that would fall into either of those categories that are proposed?
No, I noted in some of that text that it refers to the nature of activities as being typical of the surrounding rural land.
Yes.
With respect to pivot irrigators and cut and carry operations.
Yes.
For instance, so I guess that there being no particular conditions on hours of work or anything that you could link to an outline plan of works, which is one of the instruments that I am a little bit familiar with.
Can you just take me through how the typical operation would work with the raw material coming from the treatment plant? How would it be delivered? Is it through transportation by vehicle? Was it through pipes or a combination of both?
Definitely by an enclosed system of permanent pipes and pumps. So the material that we're talking about arrives from the township as 99% water and leaves the wastewater treatment plant as 99.9% water. And so it is water in nature. The residual contaminants are all soluble and dissolved, such as nitrates in the water, for instance, or phosphates, as well as pathogenic organisms, those residual ones. It's essentially grubby water.
Yes.
So it's very pumpable, and so it will be transmitted by a buried series of pipes, probably in one shot, I would say, rather than needing to be gathered and repumped.
Yes.
So the pump station would be located at the wastewater treatment plant.
Yes.
Identical to how it currently is, except that the current pump station only has to go a short distance to do a small amount of flow. This new pump station would do a larger distance and a larger amount of flow. So there would be no visual effects. We would need to, in the implementation of stage 2B, we need to choose a pipe route, or route, however you say it, which maybe makes use of some paper roads or gets some easements from some surrounding property owners. That hasn't been done yet. So that would be off of the designation. And then once it gets onto the designation, it would be gathered probably in some sort of small lagoon to allow a balancing by level increase and level decrease as it increases over the night, say, and then it's irrigated throughout the day. Or
Balancing in terms of the quantum or the quality?
Volume only. It's treated effluent. It's already as good a quality as it's going to get. Within that pond, you wouldn't want any, or you wouldn't expect any more treatment to happen. Realistically, more treatment would happen. The action of sunlight,
Yes.
Algae and biota that sort of ingests the residual components as they do in any typical natural pond would happen. These are all engineering elements, and I guess a sort of hard engineering, the soft engineering elements that we might arrive at could be, boundary planting. We could see, the pond would need to probably practically have a grade to its floor such that there would be shallow parts and deep parts. Some of those shallow parts could be wetland in nature rather than pond.
Yes.
I guess it's not really a key element. The key element is the irrigation onto the land. That would have a series of moisture sensors so that there would be a control system that instructs the irrigators when they can operate and when they shouldn't operate. And then it would be overseen by operations. The cut and carry operation would be called in when the grass or the vegetation height or crop height reached a certain croppable state, and that would just repeat. Sorry, I've just probably gone on and on about this.
That's very useful. Some of it's coming back to my memory very quickly. The pipe work from the treatment plant to the boundary of the Paynes farm or to the lagoon would all be underground.
Yes.
And would try and use roads where possible or paper roads where possible.
Yes, I think so. It looks like it would suit that. Just pop down, taking a quick look.
Yes.
The other alternative might be there is a particularly large land holding in between, perhaps talk to them about an easement somewhere along their boundary, but in general, it would be recessive.
Yes, and we're talking approximately 2 kilometres.
Yes.
Yes. Okay. Would there be any instance where the transferal of the dirty water from the treatment plant to Paynes Farm would be anything other than by pipe?
Not practically, not economically, not energy efficient to do it any other way.
Yes. Any other way presumably would be by tanker truck, presumably.
That could, when you think about what that would involve and how ineffective that would be.
Yes. I did witness that occurring in Wellington during COVID, from deliveries to the sludge to the Happy Valley landfill, to involve several truck movements. One every 10 minutes from the airport to there. So yeah, but that's not what's proposed here.
That's not what's proposed here, and I should definitely jump on that to say this is treated effluent water. The wastewater treatment plant process as a separation process tries to keep the water in and everything else drops out, and that everything else becomes the sludge. Yes. All of that sludge from Martinborough's wastewater treatment plant process stays in the bottom of the ponds, and it's only the watery component, which we call effluent,
Yes.
which would be conveyed to Paynes Farm.
Yes. Peter, bearing in mind what you've just described as the proposed operation, what component of that is being undertaken at the moment? You touched on this earlier. You said there was some irrigators being set up and there was some some disposal occurring?
Yes, and just because there is two routes for the disposal, one is to land and one is to river.
Yes.
And so,
Paynes Farm, I mean.
oh, sorry, no, there's no wastewater disposal currently occurring on Paynes Farm. The only operation is within that yellow designation, which is solid waste, which is a different operation of South Wairarapa District Council.
So the question then arises is whether the regional consent is still operative and valid. It may be that stage 2A provided that continuation, but it sounds like stage 2B has yet to occur. Is that
correct? Stage B is yet to occur, but I mean, I'm no legal, but the consent established that stage 2B would need to be done by 2030, yet the consent was granted in 2015. So I imagine that means it was still given effect to.
There's a lot of information there that I'm going to need distilled into writing, the record. In terms of the process and what the designation activity would cover. But Mr. O'Leary, it sounds like there's two components there. There's the activity itself in a broad sense, and the physical works and structures associated with the activity that the designation would seek to authorise. In addition to Peter's component, I'm going to need some description of that in a land use sense. And I'll provide a timeframe for that shortly. Okay. I think that's all that I need from you, Peter. Just Morgan, are there any questions of clarification from Peter that you require at this point?
No.
Okay. Peter, would one of the things I'm going to ask you to consider is whether the council might want to consider the volunteering of conditions on the designation. You've touched on the procedure of the outline plan of works that would be required under section 176A, I think it is, which would cover things like bulk and location of any structures, landscaping and earthworks. The procedure there is that the outline plan, and this is where your council wears two different hats. You would submit an outline plan of those works to Mr. O'Leary's team, who would consider it and come back with any recommended changes. You would then make a call on whether those changes are accepted. So that's the outline plan of works, but there's an opportunity, as I touched on in the earlier hearing, for a designation to contain what I call bottom line conditions, which might set minimum setbacks for structures. It might set up a landscaping buffer in terms of, and might stipulate the height and type of species. It might set hours of operation. I'm just going on the fly here. It might set a maximum noise limit. I don't know how noisy the equipment is, but
it's quite quiet. But at the same time, would it not be covered under the general rules of?
No, and that's
the point.
The power of the designation. The designation suppresses the zoning, and anything that's within the designated purpose is permitted to occur as of right, subject to the outline plan process for works, but unless there are any conditions governing or constraining the operation of the designation, then no. But there's a little bit of work required here, and I'm going to give a direction in terms of how that might be best be delivered shortly.
Thank you.
I just wanted to get your appetite for considering some of those matters.
Pretty healthy appetite, I think. When I consider this designation, I guess, however, also includes the solid waste component. I don't know if there's yet any rules that govern, conditions that govern that. But when it comes to just irrigating of wastewater effluent to land, it's it falls pretty neatly, I think, into a relatively quiet, obsessive operation that, yes, could be bounded within a good boundary. And
I mean, the notice of requirement that was on the screen earlier, in terms of the assessment effects, looked at probably the visual effect as being one of the main ones. So how the mitigation of that effect's codified into conditions would be of interest to me. But certainly I would not expect any duplication of conditions that are on the regional consent. They serve their own function. You might want to familiarise yourself with those so that you can take a lead from those and fill in the gaps. Okay, you can stand down. And what we probably will do now with Mr. Evans' indulgence is call the submitters that have sought to speak on Payne Farm, asking to come forward. That's Beverly Clark and Jason Clements.
I'm speaking on behalf of my mum.
Thank you.
Or not? Say there. Okay. Right.
No, you're fine there. So, Beverly, is it?
Yeah, Jenny. I'm Jenny Boyne, baptism of the Beverly Clark.
Jenny, I'll just get your name for the record. How do you spell your surname, Jenny?
Boyne.
Yes. And you're representing
Beverly Clark.
Clark. Okay, and we've got another submitter.
Alison Clements.
Hi, Alison.
Husband Jason is working in Wellington today.
Okay. And you're joint submitters anyway, I think, aren't you?
Okay.
Yes. Okay. Right. Apologies for the unusual nature of this hearing. It's a little bit out of sequence, but hopefully you've been keeping abreast of what's been going down. So would you like to lead off?
Thank you very much. Good morning. I'd like to introduce ourselves. I'm Jenny Boyne and speaking on behalf of my mother, Beverly Clark, on the proposed designation of the Martinborough wastewater land-based disposal, Payne Farm. My mum lives directly across the road from the Payne Farm and has lived there for 26 years and in the Martinborough ward for 66 years. However, is prepared to make a stand and say, not in my backyard. Both our backgrounds include sheep and beef farming. My parents had a drain laying business for a number of years, tile draining and mole ploughing a number of properties in the Carterton and the South Wairarapa. And I have a postgraduate horticultural science diploma, so we do have some street credentials when it comes to assessing the suitability of soils. And I've got no idea how the council has even looked at the soil type there because it is clay. The designated area is not council owned. It's managed by way of a trust deed. So as far as we're concerned, the South Wairarapa District Council have misled Greater Wellington with the application for discharge consents, if indeed it does include the Payne Farm on their current consent. The trust deed for this property has seen more than its share of legal opinions and court time, and it's no wonder there have been no similar gestures of philanthropy in recent times, wary that their well-intended bequests would be sold off or blatantly taken by deception. In this case, a highly productive moneymaker working farm, rezoned, designated to a wastewater treatment plant. The land designated known locally as the Payne Farm is the golden goose for the children of Martinborough. The income and net proceeds from this productive unit is allocated annually towards the upkeep or improvements that benefit the children of Martinborough, as outlined previously by Peter. Blanketing the whole area to this designation will have more than minor effects. We're appalled that the council staff, the South Wairarapa District Council staff, this is not the combined district plan, or the consultants have recommended to the elected councillors that this land is to become a disposal field for the town's waste. The income will be slashed as this land will not be sought after cropping or finishing livestock for export. It'd be nicer to have the Marsden District Council here to ask the Marsden District Council who they sell their baleage to. It's not livestock farmers. The EU don't want to eat our animals that graze on pea contamination found in most wastewater in New Zealand these days. Basically, we request that you deny or remove from the combined plan this proposed designation and ensure there'll be no more attempt from the council, South Ryde District Council, to pursue using this land for this purpose. We do have an alternate solution. Call for expressions of interest to other landowners if they would like to use the treated wastewater to irrigate their gardens or green spaces. There is a huge new development on Shooting Butts Road, or maybe even offer it to the Mountain Borough Golf Club. It's got 100 acres, also council managed, and their fairways are unirrigated. The cost to pipe it to either of these two properties would not be much further, and financially there should be no ongoing cost to burden the ratepayers for the irrigation of their 42% of the annual wastewater disposal from the existing plant, because the other people would be piping it to them, using it. Thank you.
Thank you, Jenny. Did your mother want to add anything? Would you?
Yes, I do. As that gentleman was speaking, is there any guarantee that the water is pure and that it will stay pure? There'll be no breakages or anything else? Can the South Ryde District Council have a written guarantee for us residents that nothing would happen with the water that they say is going to be pure? Because I don't believe it will be, because we have the same problem in Greytown with the water there. So unless they can come up with a very good solution, just don't have it. Shouldn't be there.
Thanks, Beverly. Was there anything else?
No, it's been a lot.
Just noted there, and gentleman you referred to will have an opportunity to respond to that in a short moment. Nothing for.
No.
Thank you, Jenny. Alison.
Before I start, can I comment on Jenny's?
Yes.
Just to add, myself and my neighbours, who are most of the submitters, are the Martin Olive Grove, and we are opposite Payne Farm.
Okay.
So 2 summers ago, when we had that incredibly wet summer, we were practically underwater for the whole summer. We've lost a lot of olive trees. Just on my land, we have 460, and we've lost 40 olive trees out of that standing water. It is an incredibly clayey area. There's probably about that much topsoil before you hit solid yellow clay. It's really disgusting. And putting more water on top of clay, just from a layperson's perspective, seems like a poor idea. But I'm not here to comment on the environmental side. My role is to comment on the legal side. And that's going to be the focus of my submissions. So we can see from the officer's Section 42A report that reference is made to the resource consent granted by the Greater Wellington Regional Council in 2016. That's the date that I have.
Okay.
And that the proposed amended designation purpose is operation, maintenance and improvement of a wastewater disposal facility. The crux of the problem that this proposal and SWDC have is succinctly set out at paragraph 90 of the report, which says a consideration of alternative sites, routes or methods is not considered necessary as the site is owned by the requiring authority, and the activities to which the designation relates will not generate significant adverse effects on the environment. Regrettably, that statement is factually and legally wrong. So wrong, it's actually embarrassing. SWDC does not own Payne Farm, and it has no right to use the land as though it were a council asset to be used for council purposes. It holds the Payne Farm land, but it does not own it. It is the trustee. Unfortunately, it seems to me that Wellington Council was equally misled in 2016, and the effect is that the resource consent of 2016 really isn't worth the paper it was written on. Let me explain. Payne Farm is a trust asset. It was bequeathed by George Payne in 1936, I believe, and far from being owned by the council, it is held in charitable trust by the council. A trustee holds trust assets solely in order to manage them, not to do what it likes with them. And it's been extraordinary listening, I think, earlier to the point that was made was, well, they are managing this land, there's a trust, blah, 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 blah. And so let's go straight into, they're going to put wastewater all over it. Well, hang on. The trustee owes a legal duty to operate the trust strictly in accordance with the trust terms and for the sole benefit of the trust's beneficiaries. I am going to give you a written version of this, by the way, so you don't need to take copious notes.
That's fine.
A trustee must not use trust assets for self-use. That's basic Trusts Law 101. It would be a conflict of interest as well as a violation of the terms of the trust and of the law. In this trust, the terms say that the property is held by the council on behalf of the inhabitants of the township of Martinborough. That means Martinborough inhabitants are the trust beneficiaries. And the purpose of the trust, this is in writing, is, so far as possible, to be made available as a sports ground for the residents of Martinborough and a playground for the children. George Payne's desire for the land to be a sports ground and a playground for the children could not be further away from the council's proposal to use the land as a place to distribute wastewater. Now, look, I acknowledge trust law is all rather dull and enough to put most people to sleep, but perhaps it will make SWDC sit up and take notice to be reminded of Section 229 of the Crimes Act 1961. This creates a criminal offence of criminal breach of trust. What it says is everyone is guilty of a criminal breach of trust who, as a trustee of any trust, dishonestly and contrary to the terms of that trust, converts anything to any use not authorised by the trust. Every trustee who commits a criminal breach of trust is liable to imprisonment for a term not exceeding 7 years. And I'm sure Janice would tell you she's far too pretty to go to prison. So just stop and consider that. What the trust authorises is use of the land as a sports ground and playground. What it's currently being used for is to create revenue for those purposes within Martinborough. The criminal offence is where a trustee converts a trust asset to any use not authorised by the trust. So let's be absolutely clear. The trust does not and never has envisaged SWDC suddenly needing a place to distribute wastewater and deciding that George Payne's land is a jolly convenient spot for that. Going down that direction risks the trustee committing a criminal breach of trust. There's also the Trusts Act 2019, which sets out trustees' duties. As a trustee, SWDC must follow 5 statutory mandatory duties, including knowing the terms of the trust, acting in accordance with the trust terms, and to exercise its powers for proper purpose. On top of that, there are 10 default statutory duties that the trustees must follow. The relevant ones are to exercise reasonable skill and care, to invest prudently, not to exercise any power for a trustee's own benefit, not to bind trustees in the future, and I'm going to come back to that one, to avoid conflicts of interest, to act impartially. I hope you're seeing as many red flags here as we are. In short, it doesn't matter a jot what resource consents might have been passed by an unknowing and ill-informed Wellington Regional Council. SWDC as trustee must still comply with the statutory obligations and default duties of trustees in the Trusts Act and comply with the trust terms. Those take absolute priority, and a resource consent or designated purpose don't trump them. So by asking the combined district plan to designate the Payne farmland in this way, and by giving the panel, the idea that it might even have authority to use the Payne farm for distribution of wastewater, the council is in material breach of its trustee duties. There's clearly a conflict of interest between SWDC and its duties as a trustee and the benefit of the community. It isn't acting impartially. It's trying to exercise its power as trustee for its own benefit because it hasn't planned ahead for wastewater. Coming back to that one that I said I would come back to, it's binding trustees in the future around the use of that land and future exercises of discretion. So there's a couple of facets that I just want to flag on this. As a trust asset, Payne Farm needs to be used for the best revenue generating purposes. If designation of the land would restrict that, it purports to deprive the trust in future of the ability to use the land for the specific purposes of the trust, whether that be leisure, as specified by the trust, or use that would generate a much better trust income than whatever the council will pay, if anything, for distributing wastewater over the land. If the land will be permanent, this is the second one, if the land will be permanently impacted by the proposed designation, and obviously we're alarmed to be hearing about earthworks and lagoons and the potential stuff that's going to be spread all over the land, that will permanently affect the trust's ability to use the land or earn income from it. The report alleges that the designation activity won't significantly adversely affect the environment. Now, we dispute that. It's demonstrably not true that wastewater disposal won't impact the future use of the land, given the reputational damage from Carterton and the high value of our food growing industry in Martinborough. And for that, I can only refer you to my neighbours' submissions because they've gone into more detail on that. But that really isn't the point from the Trust's point of view. The question is not whether the designation will adversely affect the environment. It's whether the designation will adversely impact future use of the land and thereby unlawfully bind trustees in the future. It should be clear as day that in proposing to designate the land in this way, SWDC is acting in conflict of interest with its role as trustee and the interests of the trust and beneficiaries. What's more, it's trying to get the combined district plan to rubber stamp this, not for the trust's benefit, but because SWDC has a different problem, where to dispose of its wastewater. So just to summarise, SWDC is already in breach of its trustee duties, and it's trying to get the combined district plan to collude with it so that it will look like SWDC has some sort of mandate to do this. Yet trust beneficiaries reminded the council over a year ago that its proposed use for the land is in conflict with the trust and with its trustee duties. SWDC has been told by the beneficiaries of the trust that it cannot take the actions proposed. That's really all there is to it. The resource consent obtained in 2016 is flawed and irrelevant. It's abundantly clear that SWDC isn't up to being a trustee. Nobody there understands a trustee's duties, and even when people get up to speed, personnel churn means that knowledge is being lost repeatedly. That's why we've ended up where we are now, that a council wrongly thinks Payne Farm land is SWDC land to use as it likes, and is asserting that fiction to wider parties such as Wellington Regional Council and the Wairarapa Combined District Plan to mandate it to do what it likes. Frankly, SWDC is skirting very close to a criminal offence. When a trustee goes rogue, the appropriate step for the trust and the beneficiaries to take is to replace it with a trustee who will act in accordance with the trust's terms and in the best interests of the trust. If SWDC keeps pushing the beneficiaries on this, that is exactly what will happen. So, revisiting paragraph 90 of the report, the council has made the foolish mistake of not having any plan B for where to put its wastewater. It has lazily just thought it can use the Payne Farm land as that dumping ground, even though that land does not belong to it. It can no more put wastewater on Payne Farm than it can put it on my land. Neither land belongs to SWDC. It's as clear a case as you could get that there is a critical conflict of interest between the interests of the trust and the interests of SWDC. So for the reasons I've set out, we submit that the panel must not only reject the proposed revised designation over Payne Farm, but must also reject the entire designation over Payne Farm land. This is not council land, and it is not lawful to restrict or curtail what that land can be used for. I'm afraid it isn't available for wastewater purposes. SWDC must find a plan B because plan A is not lawfully available to it.
Thank you. And if you could email, do you have hard copies of that, or
I have a hard copy and I can email it to you once.
do you email it to Ruth? And
Ruth's details.
thank you. And Jenny, could I also, you had some speaking notes also. Could you also email those to
I can read.
And what we'll do is we'll post those materials on the webpage under presentation material so that everyone has access to them. I don't have any questions on that. What I do have to say is that it's not part of my jurisdiction to adjudicate on trust matters.
Best what we want to alert you to is that there is a huge problem with what SWDC is trying to do.
Yes.
It doesn't own this land. We don't know why it thinks it can get a designation over it.
Okay. I think you hit the nail on the head where you said, notwithstanding what resource consents might be held or what designations might be approved, land ownership details and trust details need to be resolved first. And that's probably going to be my starting point. I'm not going to be digging into the details of the trust, but I appreciate the background. But essentially, the ability of the South Wairarapa District Council to implement either the regional consent or any designation that may or may not be approved will depend on land ownership matters being resolved, as is the case with any work. In a particular situation, I might apply to operate a pig farm from your own land. I might be granted consent, but my ability to implement that consent depends on me having approved from you as a landowner, as through a lease or acquiring the land. So I think the situation you've outlined in relation to Payne Farm is no different to that. So my focus will be clearly on the planning aspects of the designation. As to the ability to implement that designation, that's something for South Wairarapa.
If you were to designate it,
It's not me.
going back for your pig farm example, if you designated my land as a pig farm, would that have any impact on my ability to use my land, or would it only impact if the council were then to acquire my land?
Oh, it's an observed example, but if I was a pig farm and I, whatever reason, lodged a resource consent to operate a pig farming operation from your land, I mean, my chances of being able to implement that consent, and even if it was granted without your authorisation, are zero.
And I mean, that's the consent, which is obviously what the Wellington Regional Council has given. But what about this designation?
The designation doesn't convey powers of purchase. There are Public Work Act requirements to be gone through if that's the case. But all I need to be satisfied is that the test of section 171 of the Act met, and you've quoted a paragraph from that in section 90. I need to have it, and I'll read you because it's relevant to all new designations. Just bear with me. I'm paraphrasing here. I need to be satisfied that when I'm considering this designation, that I must consider that the effects on the environment of allowing the requirement. I must have regard to national policy statements, regional policy statements, proposal plan. It's under A. I must have regard to whether adequate consideration has been given to alternative sites where the requiring authority does not have an interest in the land. That's not ownership necessarily sufficient for undertaking the work, or it is likely that the work will have significant adverse effects. So, and then I must also consider whether the designation is necessary for achieving the objectives of the work and any other relevant matter. That's.
You need to look closely at whether it has an interest in the land, because being a trustee doesn't give it an interest. It doesn't have a lease over the land. And I think since all of this was first proposed to the regional district plan, SWDC has been taking much more notice of this and has been taking legal advice from Simpson Grierson. And our understanding is that they have had a lot of weird flags waved at them. So before your colleague who was giving submissions before goes away and spends a huge amount of time on this.
Certainly not my colleague.
I think there's the gentleman. I would think that they should probably be talking to SWDC about whether they're wasting their time.
Just be aware that the sufficient interest relates to alternatives only.
We understand alternatives are being explored.
Okay, I don't have any further questions. Thank you for your time. Before I invite Peter back, I'm going to just turn to you, Field, and
David,
Will you clarify one for me? I believe.
sorry, two people speaking at once.
Members of the Martinborough Community Board.
Yeah, and what's your name?
Karen Crone, the surname is Krogh. We've really come today to support their submission.
Yes.
And I believe that the word support appears in the paperwork somewhere, implying that we support the application to use the land as waste.
Yes, and your name, sir? Storm Roberts.
Just to describe it.
Hang on, please. I'm just recording this. So the community board is listed as a further submitter in support of one of the submitters that we've just heard from, Kimberly Clark.
Good.
Thank you.
Excellent. That's correct.
And Storm, you sought speaking rights on Friday.
We just felt the time frame was too tight for us to get into that
Yes.
scenario. Just to explain who we are, we're the Martinborough Community Board.
Yes, I understand.
We are the governance of Payne State.
Yes, and you lodged a further submission. Did the community board authorise the lodgement of that submission?
No, we didn't at the end because we made a mistake in our application. So we decided to not do that, just support BF's application.
Yes, but was there any resolution granted by the community board
Yes,
to
there
do?
was a resolution demanded by the community boards. We did it after the event, special, community board meeting.
Yes, and there'll be paperwork showing
There will
that.
be paperwork in the agenda notes.
Okay, well, in that case, come up to the table. Karen? Now, I will ask to see that paperwork, so I'm giving you the benefit of the doubt.
Sure, we will get the notes.
And Karen, you'll be familiar as to why I asked for this, because you presented to the panel on an earlier hearing stream, purporting to represent the community board. And we asked for paperwork to show that the community board had, in fact, authorised that. You failed to provide that information and presented on your own right as Karen Crowe.
At the time, I understood that retrospectively we presented, but is that not adequate?
We have not
Really?
seen any authorisation. Now, you might think that I'm setting a high bar on this, but as a community board, you are a quasi-public authority.
Yes,
It-
I understand that.
Takes you out of the realm of the normal lay
I
submitter.
did understand that we had retrospectively passed a resolution that my,
You may well have current, but
we haven't cut it.
there's not
Come,
at all.
Anyway, we won't,
And for that reason, we treated your submission
it's personal,
as a personal submission.
understand.
So now I'm going to give you a maximum of 5 minutes to speak in support of the further submission.
Okay.
Yes.
Yeah, Karen, you can go first.
Okay, so I think that Alice and Bev have touched on the most crucial point, which is the ownership of the land, the ability of the council to actually do whatever they like with it. And the fact that they have in documents relating to this matter stated in writing that they own the land, which is absolutely incorrect, as Alison has said. And in terms of our jurisdiction and how we work with the community, almost exactly a year ago, we held a well-attended public meeting. And the message that came from the community at that meeting was that the people of Martinborough reject soundly the proposed land use for Payne State.
Yes.
That it will prejudice the use of that land into the future, that any cropping or apparently our understanding is that anything grown on that land once it's had wastewater applied cannot come into the food chain. So any stock, any crops will be very prejudiced. They've been grown on land which has had wastewater applied to it. So the community is very against this proposed use for the Payne State land. And that's come across loud and clear.
How do I reconcile that with the number of submissions that have been received to the proposed designation?
Now, I have seen some of that paperwork. I'm sorry, I haven't been spent all my working hours looking at this, but I have looked at some of the submission paperwork that was purported to back up this proposal. And from what I saw, those documents talked about wastewater generally being applied to land, and they did not specifically mention the Payne State. I haven't seen any documentation that was consulted that mentions Payne State. It just mentions that the South Wairarapa District Council are planning to upgrade their water infrastructure, and that wastewater will generally, the plan will be that treated wastewater will be applied to land.
Yes, no, I understand that.
Generally, not.
Probably poorly phrase my question to you. There are 12 submissions lodged opposing
Yes.
Paint Farm and one further submission, which is the community board supporting Beverly Clark's submission
Yes.
opposing.
That's right. That's right.
So are you saying that those 12 submitters are representative of the community feeling in Martinborough as it relates to Paynes Farm?
If
I think that, if I can interrupt, I think that might be too hard for us to say specifically if we could do that. We certainly would take from the meeting we had with the public that there is general support for the stance being given by Beverly and others, that the use of Payne Farm for this designation is not because the ownership is unclear. If you understand what I'm trying to say, it's because the ownership is unclear. And historically, we have discovered since our triennium that many matters relating to Payne Farm and the activity of the trustee are not in actual fact in sync with how a trustee should be acting.
Okay, well, yeah, okay, I understand that. It's just that Curran said that the community was opposed to trying to reconcile that statement with the number of submitters received.
So what happened, my understanding is our public meeting happened after the submissions were concluded.
Yes.
So we couldn't actually use that as a support document. But the clear definition, and I led that meeting, the clear definition from that meeting, and we had a raised hands opinion, and to give an indication, we had about 100 people at that submission, at that meeting, was clearly to support the actions that we were taking.
Okay, thank you. Karen, was there anything further you wanted to add before I asked Storm to give his summary?
So I think.
Thank you. Anything additional?
All we decide, we support, and this is why we came to here, we support the actions that have just gone past from Beverly and Allison.
Yes.
Because they are speaking from the membership of the public of Martinborough. And that is the clear indication we have. And we want to support that because we think there are ways to get out of this, but they're not in this designation. I listened to your comments earlier that said, perhaps designation could be made, but doesn't need to be enforced or can't be enacted, which is something there, but that to us is still a bit of a hazard because you've designated it and you can do it. And we're trying to say, don't designate it because that's not what should be.
Just to clarify, Storm, what I said is that I don't have any jurisdiction.
Okay, yeah, but you gave, I was looking at the example of the pig farm.
Yeah.
I can understand that sort of quite clearly. And we would not want to be put in the position that say that we can't cooperate with South Wairarapa, but South Wairarapa need to also to reach out and understand its position as the trust. And this is the premise in which we come from. And the examples given by Bev and Alison are pretty much the average take of what the community feels like.
Thank you. If I could invite you to provide some documentation that shows that the community board have authorised the lodgement of the further submission, that would be useful.
Is this submission? Just let me get clear. This is submission in support of Bev.
Yes, the further submission that was lodged last year.
So look, we'll go back and do the agenda checks because we did have to go through a process to get it correct. And so I'll go through and get that checked. I'm just not quite sure if I can put a finger on the date at the moment.
Thank you. Thank you both for your presentation.
Thank you.
Now, Morgan, you deal with this matter at paragraph 70 through to 105 on your 42A report.
Yes.
You provided a high-level summary in your hearing statement this morning. Are there any particular matters you want to bring to my attention in light of what you've heard in the preceding 90 minutes?
For me, I think there needs to be a clarification of the land ownership. That's unclear to me based on what I've heard at the hearing this morning, and I think further clarification is needed from the requiring authority on that.
And in particular, what's that clarification? Is it a clarification in relation to section 171? In relation to? Sorry,
the interest of land in relation.
Yes.
Yes, I think that would be useful for the requiring authority to provide a comment on section 168A 3B.
And that's the equivalent, isn't it, to 171?
Mm-hmm.
Just can you read that out for the purpose of those that are present?
Yes. Just let me find the correct wording. So when considering a requirement in any submissions received, a territorial authority must, and then it lists multiple matters. But the one that I'm looking at here is whether adequate consideration has been given to alternative sites, routes and methods of undertaking work. If the requiring authority does not have an interest in the land sufficient for undertaking the work.
Yes. Okay. So that's really an equivalent of section 171, isn't it? But for territorial authorities. Yes. And you accept that would affect a determination as to whether a consideration of alternatives is necessary or not.
Yes.
I noticed that 168A 3B requires consideration of alternatives if the authority doesn't have an interest in the land sufficient for undertaking the work, or it's likely that the work will have significant adverse effects on the environment. Are you saying that B is not achieved in this case, and therefore you need some further information on, sorry, not B, B2 is not achieved, and that you need further information on B1? Is that what you're saying?
I guess from what I've heard this morning from the submitters is that there's an issue around the land ownership, and it's unclear around the leasee and land ownership. And so I think that clause B1 is what is around the interest of land sufficient to undertaking the works. So if the requiring authority could provide information on that, it would be useful. But in terms of B, at the second point there around significant adverse effects, that's covered in the section 42A report, and it relies on the regional council consent being granted.
Yes. Can you take me to the section of your 42A where you give a summary of the effects?
Yes, I can. Paragraph 85.
Yes.
Um,
And you've come to the conclusion that the visual effects are minor.
Yes, so I talk about the visual effects around wastewater disposal infrastructure, so things like irrigators and pipes, and
Yes.
it being similar to or what's typical within a rural area within the Wairarapa. I also did note that sunscreen planting around the perimeter of the site would mitigate any visual effects, and
Yes.
I think that's what the requiring authority will be looking at in response to your questions from this morning.
In terms of 168 3B, Roman numeral 2, is it your view that the work will or will not have significant adverse effects on the environment?
Not.
On that basis, is there a need to consider alternative routes, methods or sites based on the chapeau wording of clause B and the word or between Roman numeral 1 and 2? Read it to you. Whether adequate consideration has to be given to alternative sites, routes or methods of undertaking work if 1, the requiring authority does not have an interest in land sufficient for undertaking the work, or it's likely that the work will have significant adverse effects on the environment. That's what's in the trades called a disjunctive test.
Mhm.
Only one test needs to be satisfied to enact the requirement. On that basis, do you still consider that that alternative sites, routes or methods need to be considered based on your conclusion on effects?
It doesn't have to be both. And because I'm saying that there's not going to be significant adverse effects on the environment, the requiring authority does not need to do BI.
Mention something from a legal basis. I don't think that's right.
Sorry, you've had your opportunity. Sorry.
I just think you're interpreting legal writing incorrectly. Only one of those needs to be satisfied in order for the preceding wording to be right. So if the preceding wording is you have to explore alternatives if either A or B, if A is met, then you have to implement the preceding wording. So that would mean that you would, if A is met, which is inadequate interest in land, then you have to explore alternatives.
Thank you for that. Is there any further sections within that out of your 42A report that you'd like to draw to my attention?
And no, it's all set out within the section 42A report.
My final question to you is, based on what you've heard, have you changed your recommendation in any way?
I'd like to hear back from the requiring authority before I can make a recommendation.
Thank you. And on the subject of conditions, what's your position currently?
I'd like to see what the requiring authority puts forward in terms of conditions and the matters that you spoke about this morning.
Thank you for that. Can I invite Peter back to the table, please? So Peter, this is an opportunity for you to respond to any of the matters that have been raised by submitters or the reporting officer. Not an opportunity to reiterate your case.
Excuse me, can you sit at the end of the table? Because I can't hear you.
Okay.
You'll be required to speak, but sit at the end and see about those. Thanks.
This lady's had a clarification that I'd like to respond to, I think, around the purity of
Yes.
wastewater. I think that was more or less the only one I noted, but I'm happy to be reminded. I was a bit confused, ma'am, about the where you got the notion that wastewater treated effluent was pure. We would definitely not consider wastewater treated effluent to be pure
Well, you
water.
give it 99.9%.
Well, that's water,
Yeah, but
yes.
that's what worries me. When you
Okay.
have a breakdown,
Yes,
what's going to happen? The ground's going to be, well, it's going to be no good anyway because you want to put it on there. But I just don't like when they quote you 99.9% that it's going to be good. It'll never happen.
Yeah.
There'll be always a breakage somewhere along the line.
yes.
Here's the gentleman's opportunity to respond to that.
Yeah, that's
Well, I'm trying to figure out how to respond best. I guess when I talk about something that's 99% water, most people might think, hell, that's pure. But in our knowledge, when you've got 100 parts per million of a contaminant, that can be quite contaminated. And so 100 parts per million is sort of 0.0001%. So even that, yes. So I certainly wouldn't want you to take the opinion away that someone saying something is 99% water means that it's pure. because impure substances can be present in very small concentrations. So,
Thank you for that clarification, and thank you for raising that issue, Beverly.
Well, I wanted to know.
What would you say about the quality of the discharge, though, generally? How would you categorise it?
Put me on the spot, why don't you? Oxidation pond effluent generally used to be acceptable to go into rivers in the 1940s and 1950s. Subsequently, oxidation pond effluent is generally viewed as being acceptable for small communities and to large environmental areas, but in high population densities, oxidation pond effluent would be considered unacceptable. And again, the difference is for on a particular measure, you might get 100 parts per million out of an oxidation pond where you'd get 10 parts per million out of a higher quality system. So all of South Wairarapa District Council main towns are oxidation ponds with some pre-treatment and post-treatment. So generally, if I'm to be honest, we should be trying to do better, and that is what the resource consent process was characterised was, may we continue to treat this wastewater as well as we can, but do better, and hence the staged consents that we have. So there is an obligation on South Wairarapa District Council to continue improving the quality of the effluent out of the wastewater plant.
Why can't you, if it's 99.9% pure, why can't you put it back into the river? Like, instead of having to pipe it 2 kilometres.
I think the point is that you're not saying it's 99% pure, you're saying it's 90% water.
Why can't it go back into the river? Why having all these pumping stations and whatnot if you can purify it on site?
So it's unacceptable to put something which has got 100,000 parts per million, which is what I'm saying, 100,000 parts per million of a pollutant is considered to be grossly polluted. And so it's unacceptable. So for quantification purposes, the cleanliness of the treated effluent out of all of the South Wairarapa District Council oxidation ponds is in the vicinity of 50 to 100 parts per million of residual pollution from all of our activities in the townships that are treated from.
I think moving on, Peter, that's the response to that direct question. Was there anything else you wanted to respond to before I provide some directions on further information?
Nothing within my wheelhouse, I don't think. Thank you.
There are 2 areas that I require some further information on. First is a written explanation of the operation that's proposed and the structures that would be associated with that operation under stage 2B. You've given a verbal description of that today, but I think for the record I need to include that into the record in a written form. Secondly, I'd like you to give some consideration as to the need for and type of conditions that you may wish to volunteer. The starting point is, I guess, you visiting the conditions on the regional council consent and seeing what baseline they establish from a discharge perspective, and not trying to duplicate those, but to address the matters that Ms. Fallowfield identified in her paragraph 85.
Yes, culture, yeah.
Dealing with landscaping and any other matters. I can't compel you to do that, but I think it would be in your interest to suggest some conditions.
if I may ask, how long are these actions typically?
I'm just going to move to
Okay.
the third component. Is entirely up to you. Question is whether you want to address the issue relating to the requiring authority having a sufficient interest in the land under section 168A 3B, Roman numeral 1. And I certainly take the point that that Alison raised. I think that those clauses are probably conjunctive and both need to be satisfied in terms of whether the consideration of alternatives is something that I need to address. So, but if you or your planning advisors think otherwise, that the tests are disjunctive, I'm happy for you to tell me that also. So I wasn't trying to take a position on that. I was just trying to test with Ms. Fallowfield what she thought that section of 168 was saying. As to the time frame, I will issue a minute to formalising these directions, but I suspect that this is something that you might want to give some thought to, and I don't want to constrain this in any sense. So I'm thinking at least 10 working days, if not 20 working days, for this information, because the recommendations that, or the decisions that are issued on designations take a different path to the decisions that are issued on the district plan provisions. In many senses, the district plan is just a vehicle for notifying the designations. They then have their own criteria that we've discussed this morning under 168 for council designations and 171 for other requiring authorities. So the decisions and recommendations that will come out of designations will be quite separate from the decisions that we issue on district plan provisions. So there's probably less urgency in that sense. So I'm thinking probably 10 to 20 working days for that exercise. And then it's a matter of Ms. Fallowfield perhaps giving her final position in relation to that information that you supply, particularly any conditions. Because, okay, anything arising from anyone procedurally?
Not procedurally, sorry, I'm confused. So if you've got the designation as this pain farm and then the wastewater is 2 k's away, does the council have to have its designation like the next time you review the plan to allow the water to go, if it is approved, we can get rid of it, to go through the other person's bit of land in between? Like, would they not have to designate from A to B? Why have you got a bit, can't fly unless it's flying there?
Yes.
I'm just confused as to why they didn't designate the whole shebang.
Yes, it may well be that the pipe work that's required might be a permitted activity under the network utility provisions of the plan. I don't know, but if it's not, some form of planning authorisation would be needed in addition to landowner agreement through easements if it's not their own land, such as paper roads or illegal roads. So very good question. But it's probably something I don't need to address my mind to.
Just about a big farm, get the consent.
Yes.
Doesn't matter.
It's another cog in the wheel, if you like. And I'm sure Peter's learning this very quickly on the hoof.
Thank you.
Okay, well, thank you everybody for the spirit in which you've attended the hearings and which you've shared information. I appreciate that. The hearing's adjourned, and I'll issue a minute confirming the directions I've given towards the end of this week. But don't hold off proceeding on that information, because the directions won't be any different to what I've given verbally. Okay, we're going to adjourn the hearing for 5 minutes just for a comfort stop, and then we'll proceed with Eastleigh's submission in relation to Riversdale.
I'll just ask you a question.